I'll be presiding, and sitting with me today is Judge Freyre on my right, and we are happy to welcome Senior Judge Gail Miller on my left. We have two cases on our 1:30 docket today. People v. Lehman will be heard first. We will take a break after People v. Lehman to reconfigure the panel for our second case, which is People in the Interest of HS. So if attorneys are present for that case, there will be a short break. Counsel, do you have any questions about our oral argument instructions? No, Your Honor. Okay. And as you both probably know, we are now live streaming all of our oral arguments, and they are recorded. They will be available on the website. So if there is anything confidential in your arguments, please conduct them accordingly. And to our counsel and our guests today, can you please turn off any electronic devices? They do interfere with our recording equipment when they are on, even if they are silenced. We would appreciate that. With that, People v. Lehman is called. You may approach when you're ready, counsel.
May it please the court. Your Honors, my name is Laura Harvell, registration number 47477. I appear this afternoon as counsel for Cindy Lehman, the defendant appellant in this case. This comes before the court due to the trial court's error in accepting an untimely motion for restitution from the prosecuting attorney in Ms. Lehman's case. There is first an error of law, and this court can resolve this issue on that error alone. The error of law is as it relates to the application of Colorado Revised Statute 18-1.3-6032. In briefs, the parties have argued the terminology as it relates to extenuating circumstances or good cause. As a threshold matter, this statute does not apply. What 6032 says is that the prosecuting attorney is to provide information to the trial court, and the prosecuting attorney shall file this information with the trial court within 91 days of conviction if not available before the order of conviction. So at the outset, the information submitted by the prosecuting attorney in this case was available in discovery. The trial court notes that in its ruling on December 2nd, 2016, and that is on page 6 of that transcript. So the court notes first that there is information available before the order of conviction, and that is the basis for the prosecuting attorney's request for restitution. So that subsection 2, does not apply because that information is already there. Second, what subsection 2 says is the trial court may extend this date if it finds extenuating circumstances affecting the prosecuting attorney's ability to determine restitution. I reiterate my argument on this point, that there are no circumstances affecting the prosecuting attorney's ability to determine restitution. The prosecuting attorney leaves Ms. Lehman's sentencing in June, and all of that information is available. And that could have been filed with the court immediately.
Well, I'm not sure, the prosecutor's name is Kyle, and sometimes that's a man and sometimes it's a woman. But if the prosecutor lost the file, how is it available?
The record reflects that the file is misplaced within the district attorney's office. So I submit that that is available. The trial court on December 2nd considers that, or states that the district attorney's office didn't have access to their file. I disagree with that characterization. The district attorney's office did have access. It was in their office. What they argue is that it is misplaced. And Judge Miller, further, the concern is that the trial court does not inquire about what misplacing your file means. We have no indication from the record of how it is found, what happens after it is found, or what the prosecuting attorney does, other than we know that they say, as soon as it was found, we filed a motion for restitution, and that was untimely.
Ms. Harville, I have a question about your first argument and the information not being available, and you argue that, in fact, that it was. What was requested had been in discovery all along. But as I recall from the plea and sentencing hearing, the court inquired about restitution, and the district attorney represented that he or she was not aware at that time of what the amount was going to be that was being requested. Maybe it was different from what ultimately was in discovery, but can you explain that representation in light of your statutory argument?
Yes. The district attorney, the trial court grants 91 days for the district attorney to determine if they do in fact have everything that they need to determine that restitution amount. So we know in hindsight, appearing in November and December of 2016 on this case regarding the restitution issue, that the documents that the district attorney's office submits attached to their motion for restitution are in fact, those pages available in discovery.
Right, but there's nothing to show that in fact at the time that restitution was continued for 91 days, they knew that that amount was going to be the amount they were requesting. Is that right?
No, Your Honor, that is correct.
Okay.
I am not submitting that the district attorney's office knew that this amount was there, that they knew exactly this was happening and delayed unnecessarily. Simply that in hindsight, when we look at this, we do know that they had all of this information available.
Okay.
And even if the issue of having this information available before the order of conviction does not in and of itself require relief, I submit still that 6032 does require or does mean that the statute doesn't apply to these circumstances because these are not circumstances affecting the prosecuting attorney's ability to determine the restitution. And in fact, the trial court says exactly that on December 2nd, 2016, and that's on page 5, lines 5 through 10. The trial court explicitly acknowledges these are not extenuating circumstances, or these are not circumstances affecting the prosecuting attorney's ability to determine the restitution, and then rules in favor of accepting the prosecution's untimely filing. Should this court determine that the provisions of 603 subsection 2 do apply, I still submit that it is appropriate and request this court to reverse the restitution order entered against Ms. Lehman and to remand this case with instructions to that effect. The reason for that is that the trial court accepts the prosecution's untimely filing based on a legal standard essentially of its own making. What the trial court says is relying on the facts and circumstances and the cumulative effect of all of these facts and circumstances. These warrant finding extenuating circumstances. So first, that is an inappropriate legal standard. The idea that consideration of facts and circumstances and the cumulative effect of those is in fact error. Magnifying that error are the bases on which the trial court relies to make this finding. First, the trial court says that Ms. Lehman is on notice related to restitution. I am not going to spend a lot of time on this point. This court has spoken regarding notice in People v. Turasek, and that is at paragraph 17, stating that the argument that a defendant is on notice and therefore does not suffer prejudice from a late filing related to restitution is what this court has said is that the same could be said of any convicted felon. Secondly, the trial court says that Ms. Lehman is not prejudiced by the prosecution's late filing and the court's acceptance of that late filing. And the trial court's words are, she will have an inability to pay that restitution because she is homeless. That too is an error. It is an inappropriate basis on which to find that the prosecution's failure to comply with the court's order to file necessary documentation within 91 days and the failure to comply with the mandate of the General Assembly that error is not obviated by the fact that Ms. Lehman may be homeless and may not have $36,329.41 to satisfy the judgment that's entered against her.
Excuse me, but assuming we agree with you on these points, What is the standard of review? You indicated that it's a constitutional harmless error case, and I'm puzzled by where the Constitution comes into this.
Your Honor, I'm happy to clarify, I believe, the argument in my opening brief. I would submit that the standard of review here is de novo, as it is this court's interpretation of the statute. That being my first point raised, that this is interpretation and application of 18.1.3.6032. And a plain reading of that statute shows that it is not applicable here.
Okay, but still, so that, therefore, it wouldn't be constitutional to be,
Yes,
but that's, you still have to apply a harmless error test, don't you?
yes.
And why is the error harmless here?
The error is not harmless.
Excuse me, why is it not harmless?
The error is not harmless because Ms. Lehman is prejudiced by this order against her. This is a real sum of money that the court assesses. To say that Ms. Lehman is homeless and so she's not impacted by this simply because she can't pay it is inappropriate. And to say that under these circumstances, an individual, regardless of their socioeconomic status, is not impacted or harmed by the ordering of a $36,000 restitution order defies logic, Your Honor.
Counsel, would it matter if the order was $36 instead?
No.
And why not?
A real sum of money, I think, of any amount can have an impact on an individual. But Judge Freire, more importantly, precedent in this case means that the prosecuting attorney can file outside of a court's order requiring a filing within 91 days, can file outside of the statutory requirement, the mandate of the General Assembly, and simply say, we lost our file, and that's good enough. It's good enough for us to say we misplaced our file, and that's good cause. And so it's really not the amount of money that is truly the issue here. What is at issue is the state's requirement to comply with the law. Your Honors, I'm going to ask to use my remaining time for rebuttal.
You may. You will
Thank you.
have 3 minutes and 40 seconds for rebuttal.
Thank you.
Good afternoon. May it please the court, my name is Maria Safrias. My attorney registration number is 38746, and I'm here today on behalf of the people of Colorado. Your Honors, in this restitution case, the trial court order of restitution should be affirmed because it's factual determination that there were extenuating circumstances to extend the 91-day time frame for the prosecuting attorney to submit restitution information and a motion for restitution to the trial court was not an abuse of discretion. And it's important to underscore that that is the standard of review of the trial court's factual determinations, abuse of discretion. But it's also very important to underscore in discussing this case here today, the purpose of the Restitution Act. The entire purpose of that act is to better enable crime victims to receive full restitution. The whole point in revamping the Restitution Act in 2000 is because the legislature recognized that the collection, assessment, distribution of restitution, the procedures to do that were ineffective and inconsistent. And so it was changed to benefit the victims. And it's important that this court apply that statute liberally to achieve that purpose.
Ms. Frias, and I agree with you on the policy of the statute, but the statute also has certain requirements for the district attorneys. Isn't that true? In terms of when they need to submit material and how they submit material to the court?
Yes, Judge Dunn, that is correct. And if I may, the we have to construe the statute as a whole, trying to give effect to all of its parts. And I think when you look at it as a whole, 603(1)B provides that the trial court should set a specific amount of restitution. If that amount is not known before the order of conviction, then within 91 days of the order of conviction. So that's the legislature's intent, that that is what's going to happen. And that is supported by 603 subsection 2, because in order for the trial court to make that specific determination, it must have the information from the prosecuting attorney. So 603 subsection 2 provides that the prosecuting attorney has 91 days to give, if the information is not available before sentencing, then the prosecuting attorney has 91 days from the order of conviction to provide that information to the court. So I think in an ideal scenario, this is all going to happen within 91 days, and perhaps in the majority of cases, that is what will happen. But I think it's also clear that the legislature expressly contemplated that this is not going to occur in every case, and so it provided 2 exceptions. So under subsection 1B, it states that the actual determination of that specific amount of restitution can be extended for good cause. Similarly, under subsection 2, the prosecuting attorney, if he or she shows that there are extenuating circumstances affecting his or her ability to compile that information and to actually submit a motion for restitution, that the trial court can extend that period of time for extenuating circumstances. And implicit in that finding, if the trial court finds extenuating circumstances, then the actual determination of a specific amount will also be extended. I think that is a reasonable way to read both of those provisions together and to give effect to both of those provisions.
Counsel, in both provisions, though, it seems that the good cause and extenuating circumstances exceptions are tied to or connected with determining the amount of restitution, and that there's a link between those two. You don't just get good cause for other things, only for the prosecution's ability to actually calculate a restitution amount. And so my question is, if those two things are linked, and the court found that there were not any facts or circumstances linked to the determination of restitution, why isn't that legally determinative of the outcome? Or do you not think those two things are linked?
I think that they are linked, Your Honor, but not necessarily in the way that you've just laid it out. I think that 603(1)B is directed to the trial court because it is ultimately the trial court that is going to set that specific amount of restitution. And again, the only way that the trial court can do that is if it has the information from the prosecuting attorney. Now, I think good cause may be something that, let's say the prosecuting attorney has filed the motion timely, has filed the restitution information timely, but for certain reasons, perhaps scheduling conflicts of the parties or the victims, it's a complex medical injury, for example, and there may need to be multiple restitution hearings. The court will not be able to set that specific amount within that 91-day time frame. And so that may be good cause. And I think it's important to note that we don't have any case law construing good cause and extenuating circumstances. So I think that this would be a good opportunity for the court to provide some clarity in that regard.
I guess I'm unclear, though. What about the loss of the file affected the prosecutor's attorney to determine restitution?
Yes, Your Honor. So it's my understanding, based on the record, that some of this restitution information was provided in discovery. Now, my assessment of the actual information is that it covered medical treatment from January through March of 2016, and the printout was dated March 29th, 2016. So it must have been filed in discovery or served in discovery after that time. Now, I don't know from the time of sentencing, the record doesn't establish any facts as to if the prosecuting attorney was waiting for further information. That's not at all clear. What is clear is that at the hearing, the prosecutor, in good faith, admitted that it was a mistake. And he asked the trial court to make an express finding of extenuating circumstances. I don't know, the record doesn't show what it is exactly that happened with the file, how it was misplaced, when it was misplaced. But I think ultimately, extenuating circumstances needs to be construed broadly because the prosecuting attorney here couldn't determine that restitution amount without the file, without the information. So the misplacement prevented him from filing that information with the court within that 91-day time frame.
Well, let me ask this. It had been provided in discovery to the defendant, right?
The restitution information, yes.
So could not the prosecutor have called up the defense counsel and said, hey, we lost our file, can I get some of the stuff that we turned over to you back, or copies of it back? Or similarly, they could have gone back to the insurance company or whoever provided it to them in the first place. There's just no record that indicates that it was unavailable. I realize that the file itself may have been unavailable, although we have no indication in the record of what kind of due diligence was done to find it. But assuming that there were efforts made to find it and they couldn't find it, there were these other alternatives. They could have gone to get the same information. So why was it unavailable? Why was that impairing or making them unable to determine the amount of restitution? They could have just gotten those documents from where they got them in the first place.
I think, Your Honor, that certainly that was a possibility. The prosecuting attorney could have done as you suggested. And we don't have a record here as to what efforts he did or did not do. But again, when we look at the statute and the purpose, which is for the benefit of the victims, I think that these provisions, extenuating circumstances and good cause, need to be construed broadly. I think this case is very similar to the Harmon case, where the motion for restitution was filed 1 day late based on a miscalculation. I think that this is comparable here. It was only filed 28 days late. And that same kind of administrative mishap, if you will. And in Harmon, the Court of Appeals, the panel there, upheld the trial court's finding of good cause, which was made almost 8 months after expiration of the 91-day time frame. Whereas here, the trial court made a finding of extenuating circumstances 3 months after expiration of that 91-day time frame. So I think it would be hard to reconcile Harmon with this case. And of course, we would argue that Harmon is more applicable to our case than the Turasek case relied on by the defendant.
Counsel, the motion that was filed by the DA in this case mentioned nothing about good cause, didn't mention anything about the file being lost, just submitted the motion for restitution at 119 days, or 129, I can't remember, and said nothing about good cause. Isn't that an indication that perhaps this information was always available? And why isn't the motion on its face just invalid under the statute? I mean, wouldn't the judge have been able to just look at this and say, well, they haven't alleged any extenuating circumstances or good cause in the written motion and denied because it wasn't within 91 days?
Your Honor, I disagree with that. The statute doesn't provide any kind of timeline for when the trial court must make a good cause or an extenuating circumstances finding. So it just may be that it can make those findings before expiration of the 91-day timeframe, or as in Harmon, make it outside of that time. So, and in Harmon, the prosecutor there did not assert good cause. The statute doesn't require that in the motion itself, there needs to be a statement of good cause or extenuating circumstances. Again, it's a factual determination. And here, as in Harmon, the prosecuting attorney in Harmon argued good cause after the fact, after the expiration of the 91-day timeframe. And similarly here, the prosecuting attorney argued extenuating circumstances for the delay in filing the motion for restitution, obviously after expiration of the 91-day timeframe. So I don't think that the absence of a good cause explanation in the motion itself is in contravention of the statute. And I don't think that the statute requires that a good cause or extenuating circumstances finding has to be made before expiration of the 91-day timeframe. I think, again, the legislature intended that all these things would happen within 91 days, but provided exceptions. And so obviously those exceptions in a number of cases are going to occur after expiration of the 91-day timeframe. I'm not sure if that answered your question, but.
It did, thanks.
So, I do want to talk about Harmon and Turasek because we don't have any case law further discussing the parameters between Harmon and Turasek and what could be still compliant within that time frame that would be a restitution order that would be compliant with the mandates of the statute. In Turasek, it was a delay of 9 months. And I think the import of Turasek is that there, the prosecuting attorney didn't make any effort to explain that very lengthy delay of 9 months. So the Turasek panel didn't have the occasion to consider good cause or extenuating circumstances. Here, the prosecuting attorney did make an effort to explain what happened, and that basis that he provided to the trial court accepted that. And given that that should be, given deference and the purpose of the statute, then the trial court's order of restitution, I think, should be affirmed. But if this court thinks that some further factual findings need to be made, then we would ask for a remand on that. If there are no further questions.
Well, let me just ask you, the trial judge in his ruling, that the last transcript is when he ruled, he said, and I'm hoping they'll give you a few seconds to answer this, that the delay was not due to the circumstances affecting the prosecution's ability to determine the restitution. That's at pages 5 and 6. How do you square that with the argument you're making today? Isn't that finding cut against you?
I think that this court is not bound by the trial court's interpretation of extenuating circumstances. I think what the court was trying to say is that because the parties had argued that the information had been provided in discovery, then the trial court was trying to emphasize that, yes, it was available, but the trial court still recognized that because of the misplacement of the file, that prevented the attorney from actually filing a motion for restitution and found extenuating circumstances.
That answers my question. Thank you.
Okay. Thank you.
Counsel. Bailiff, could you please add an additional minute and 2 seconds on the rebuttal clock for Ms. Horval?
In Harmon, this court affirmed the trial court's findings because the trial court in Harmon considered 3 factors. that the filing was 1 day late as a result of the miscalculation by the district attorney, that the restitution should be liberally construed to provide for restitution for victims, and third, that the restitution amount in Harmon for one of 3 insurers could not be determined within the statutory 91-day period. There are distinguishing facts in this case that significantly distinguish it from Harmon. There are factual distinctions, and then there is also the comparison of the bases that the trial court used in this case to support its ruling to accept an untimely filing and enter this order against Ms. Lehman. I will not repeat those, but I raise it because I think it is important to consider those. That part of my second-tiered argument is that the trial court's error is magnified by these inappropriate bases that it considers in support of accepting this untimely filing. But here, in Harmon, an amount was still yet to be determined. And this court considered that in upholding the trial court's ruling. That is different here. The amount is known, and it is available to the district attorney's office. It is, in the words of the trial court, due to negligence, that it is not presented to the court within the statutory timeframe.
And counsel, I have a quick question about that kind of follows up on Judge Miller's question. So the court seems to me to make inconsistent findings, and I want to know how you think we should resolve that. The court says the delay was not due to the circumstances affecting the prosecution's ability to determine restitution. But then the court goes on to say the district attorney's office not having access to their file, even though it's arguably through neglect on their part, that extenuating circumstances do justify the late filing. So how do you reconcile that inconsistency?
I cannot reconcile that inconsistency, Your Honor. I speculate that the trial court is conflating terms as it relates to 603 subsection 1, subsection B, and subsection 2, because there is in the record the almost interchangeable use of good cause and extenuating circumstances. I don't think that this court has to reconcile that inconsistency, because I think that application of the plain language of the statute indicates that it does not apply here, and that it was misapplication of the trial court that has led to that inconsistency.
Let me ask you, getting away from extenuating circumstances, where I agree there was some, it appears to me, confusion between good cause and extenuating circumstances. But in the final order, the trial court allowed the out-of-time restitution and ordered extenuating circumstances. Did the order, was it also required to have a good cause finding to make it valid? Did the trial court also need to make a separate good cause finding? Because I didn't see that either.
I don't think that the trial court has to make a good cause determination. There seems to be a distinction in Harmon that subsection 2 of 603 applies to an extenuating circumstances determination. I think some confusion may come from the fact that then the court in Harmon says the parties have not asked us to determine or to define good cause and extenuating circumstances, but that extenuating circumstances could be a factor in determining good cause. Your Honors, having no further argument, my request is this court vacate the restitution order entered against Ms. Lehman and remand this matter with instructions to the trial court. Thank you.
Okay, thank you. Thank you both, counsel, for your helpful arguments today. People versus Lehman will stand submitted, and an opinion will issue in due course. That concludes the first case on our 1:30 docket. We will be in recess and reconfigure the panel for our second case. Bailiff may announce the recess.
The court will be in recess.
today, and that is People in the Interest of HS. This is, again, Division 6, and we have reconstituted our panel, and Judge Furman is joining us for this case. Counsel, I'm not sure if you were here earlier, just a couple reminders. We are live streaming our case, or this argument today. It will be on the website and recorded, so if there's confidential information, please conduct your arguments accordingly. Also, any electronic devices for our guests, please turn off because they interfere with our recording equipment. Any questions about our oral argument procedures?
No, Your Honor, thank you.
All right, well then, arguments may begin in People in the Interest of HS.
Good afternoon, Your Honors. Thank you. My name is Kimberly Englehart. My registration number is 44513, and I represent a mother who appeals the termination of her parental rights. May it please the court. I would like to focus today on reasonable efforts with respect to the standard of review to be used, and as well as the preservation of that issue. First, I'll start with the definition of reasonable efforts, which means the exercise of diligence and care for children who are placed out of home. That's according to People ex rel. JAS 160 P. 3rd 257. And that case is also citing 19-1-103, subsection 89 of the Colorado Revised Statute. 19-1-103-89 also states that services provided in accordance with section 19-3208 satisfy the reasonable effort standard. With respect to reasonable efforts, there is some question, I believe, about what the appropriate standard of review is. The answer brief disagrees with the standard as stated in our opening brief, and they cite AJL and CAK in support of the clear error standard. That's page 24 of the answer brief. The opening brief cites Valdez v. People. That case describes various standards of review, one of which is clear error. And I would also note that we do argue the clear error standard throughout the opening brief. However, it's very important to note the difference between the meaning of reasonable efforts and what that means in each case versus a determination as to whether or not the Department of Human Services made those reasonable efforts. So we assert that this is a mixed question of fact and law. As described in Valdez v. People, different questions may be reviewed by different standards. In these cases, the trial court must first define what reasonable effort means in this case, because 19-3208 says there must be an individual case plan. Once they determine what reasonable efforts are in that case, then they have to decide if that standard's been met. Now, Valdez has a dissenting opinion, and there's 3 dissenting judges in that opinion. And while it is a dissent, it also does make some very good points. It states, findings of fact are generally reviewed under clear error or abuse of discretion, whereas conclusions of law are generally reviewed under a de novo standard. And I think we all agree with that. It states the reasons are straightforward. De novo means anew, afresh, a second time, and cites Black's Law Dictionary. Indeed, appellate courts can and should review anew the question of whether a trial court reached the correct conclusion of law, or the right to appeal would essentially be meaningless. On the other hand, the appellate courts defer to the factual findings of the trial court because the trial judge is in the courtroom and is charged with the duty to find facts. It further states that appellate courts may not undertake fact-finding. So then it goes on to state that the tension arises between these 2 types of review when there is a mixed question of fact and law. Under those circumstances, the court may take a number of different approaches. The court may treat the ultimate conclusion as one of fact for purpose of review and apply the clear error standard. They cite several cases there. Alternatively, the court may conclude that a mixed question of law and fact demands a de novo review. For that assertion, they cite Lewis v. Colorado Rockies Baseball Club. And in Lewis, the court had to address the appropriate standard for reviewing the district court's factual findings.
So Ms. Engelhardt, I'm sorry to interrupt. I wanted to have you talk a little bit about the AJL case from the Supreme Court in 2010. It seemed to me the court there required the appellate courts to accord a discretionary standard to the fact finding. In other words, the juvenile court makes the findings of fact, and here, if we're talking about reasonable efforts, it would be reasonable efforts to rehabilitate the parent. I assume that's what we're talking about.
Right.
Do we
right.
give deference to the juvenile judge and the findings?
I think you do. I think you have to give deference to the factual findings that are made. And I think that Valdez is particularly on point because it does go on to talk about the other approaches, such as approaching the case with a de novo review while simultaneously giving deference to those historical facts and the findings that are made by the trial court.
So here, we have a parent that was clean and sober for a number of months, seemingly doing exceptionally well. And if I recall, her therapist ended up leaving, so things didn't go quite as well. But those, to me, are very heavily fact-based questions. And so I'm trying, I mean, you make compelling arguments, but I'm trying to figure out, okay, what do we do in according deference to the juvenile judge who heard the evidence?
Sure. Well, and hopefully this will answer your question. It does bring me to the other cases that are cited in this Valdez
Okay.
dissent, one of which is People v. Smith. And in that case, that's a Colorado appellate case. It involved an investigatory stop and implicated the Fourth Amendment. And the court states that the totality of the circumstances must be considered in determining whether the stop was valid. But the court also states that a reviewing court must perform de novo review of a trial court's determination that reasonable suspicion supported an investigatory stop. So they're talking about constitutional rights and based on the facts and circumstances, whether or not that stop was reasonable. So here, I think there's a definite parallel that can be drawn between determining what is reasonable as it, first of all, is defined in a legal manner and as a legal term of art, and then the facts to support whether or not that standard was met.
Well, then legally, do you take the position that the treatment plan was not appropriate?
So the treatment plan, and that is on, I believe, page 34 of the court file, and it's dated the same day that the dispositional hearing took place when that was adopted.
So it was adopted with mother in court, with counsel being there, and at the termination, the court made a specific finding that the treatment plan was appropriate.
Right, it did. It did, and we're not disputing that because the dispositional hearing, it was found to be reasonable at that time. There is, for example, a substance abuse provision in that treatment plan. That's on page 34. And like many treatment plans, it includes provision for getting an evaluation and following recommendations. But that's pretty vague. So when we look at the treatment plan and how it actually manifests mother's treatment and her recovery, those are more specific questions to be asked, and the statute requires an individualized case plan for each parent. In this case, September 28th was the first day of the termination hearing, and counsel for mother, she did cross-examine the caseworker, and she asked about mother wanting to go to an inpatient treatment program. But her mother's treatment provider actually said that's not appropriate for her because of the religious component that's required to participate there. The caseworker, when asked, did you provide an alternative inpatient program that she could seek, she said no, they didn't do that. In a situation like this where we're talking about substance abuse and we're talking about really complex relationship, the road to recovery can be fluid, and at times those things are going to change.
Sorry to interrupt again.
No, that's okay, I appreciate it.
Did the department agree to continue the termination for some time on this case? Do you recall?
I don't recall. But I do know that they acknowledged throughout the life of the case that mother was very honest. When she did relapse, she was very cooperative. And I believe one relapse, there were several sort of catastrophic events that happened in her life that caused her to relapse. And she was very honest about that. And she herself was the one seeking the inpatient program. So,
But fitness has to be within a reasonable time, which relates to the children's needs.
sure, and I think a reasonable time, it does, obviously, the children's health and well-being and best interests are of paramount concern. However, a reasonable time also needs to be reviewed in the context of what the parent is actually struggling with.
But see, that's where I'm looking at it. I mean, it's a tough call that a juvenile judge has to make. And we're looking at a cold record and saying, well, I mean, these are hard cases. I get
Absolutely.
that. And they're hard for parents, they're hard for kids. And so trying to figure out the balance between that deferential standard that the Supreme Court has directed us to do, I mean, where do we draw that line?
That's why I refer to the Smith case, and I'll get you the site on that. Let's see, it's 926 P. 2nd 186. In People v. Smith, it's an appeal where they are taking the facts and the factual findings of the trial court and affording those deference, but at the same time, they are determining the reasonableness of the conduct of that law enforcement officer at the time based on what they knew, and they can look at that in a de novo fashion while still deferring to some of the factual findings and giving
Well,
them weight.
I'm sorry to interrupt. Do you think there's a difference between those criminal cases and the standards and what we are doing on appellate review of a termination?
There's certainly different rights at stake, but we do know that the fundamental right of parents to the care, custody, and control of their children is one of the oldest fundamental rights ever recognized by the court. So again, I think there is an extremely strong parallel between these cases that are cited in this Valdez dissent, because it's talking about, factual determinations, and there's a mixed question, and they're reviewing it in a mixed way. So I understand that these are tough cases, and the trial court judge has to make really tough decisions. But at the same time, we're looking at departments that don't always provide the resources that people need. And parents that are really struggling, even when they're asking for the resources and they want to comply, they're not getting those resources.
Ms.
Counsel-
Engelhardt, I'm sorry.
Go ahead.
Just, I want to clarify, maybe I misunderstood the record on the inpatient treatment. It's my understanding in the record that mother declined an opportunity to go in-house or in-house in patient treatment that probation offered her. Did I misread the record on that? It's my understanding she declined that opportunity.
My understanding of the record was that there was a Salvation Army inpatient program that was suggested, but her treatment
therapist.
provider said that wouldn't be a good fit for her.
And then her probation officer also suggested an inpatient, or is that not your recollection of the record?
Or was it the same inpatient? I couldn't figure that out either.
And that's not clear to me, honestly.
Okay.
Well-
But she did ask for it, and if you look at the September termination transcript, page 77, 78, trial court counsel, asked about this and asked if there had been an alternative inpatient program suggested, and they said no.
Well, let me ask this. She was clean and sober for, I think, 7 months, something like that? She was in an outpatient setting during that time period.
Correct.
And that seemed to be working pretty well.
Well, and with the questioning that I was just referring to, the Mother's counsel asked, Mother did appear to have new insights as to what her triggers were, correct, in the context of this inpatient thing. And the caseworker agreed that she did. So at this point, Mother is developing the tools that she needs to identify her triggers after she, relapses.
But
So-
that's where the judge has to weigh the time that relates to the child's needs.
Right, right. So with respect to reasonable efforts, our argument for the standard of review is, and again, we do argue the clear error standard in our opening brief, and we believe that that the trial court erred in finding that reasonable efforts were made. But we would further argue that this is a mixed question, that we're defining reasonable efforts in each case based on the individual and their needs, as well as the child's needs. And so that determination, we would argue, requires a higher standard of review. And that's why we cite Valdez v. People. Ultimately, we would ask that the order of termination be reversed and that the case be remanded to the trial court with instructions.
Thank you, Ms. Engelhardt.
May it please the court. I'm Merrill Lee McWilliams, registration 16564. I'm here with the guardian ad litem, Allison Bettenberg, whose registration number is 33912. We plan on splitting our time at some point. Your Honor, this is a case that is a factual case. It is a case that has to have the clearly erroneous standard based on what it is that counsel for Mother has brought up. She talks about Mother's request to go to the Salvation Army. What she doesn't say is that Mother's therapist was Miss Zimmerman, the therapist that Mother said she really worked well with. And Miss Zimmerman said, this will not work for Mom. And it wasn't just because of the religious component, but because Mom had decided that she would not be abstinent from all substances. She was going to continue to drink alcohol, and Salvation Army required you to be totally abstinent. Miss Zimmerman indicated that she believed Mother was doing well at the level of treatment that Mother was in. Mother was with Miss Zimmerman for part of the 7 months that she was clean. There were 2 periods of sobriety that Mother had. But Mother relapsed while with Miss Zimmerman in May of 2017, continued to have treatment with Miss Zimmerman through September. I think it was a couple weeks before the first day of the termination trial. And then Miss Zimmerman quit her job. Mother never made the request, and I don't think the record states this, that she did contact Miss Zimmerman. The record says that. Miss Zimmerman indicated she could no longer provide services to Mother. So Mother was transferred to another therapist within the same organization where Miss Zimmerman used to work. Mother did not re-engage in her drug and alcohol treatment. At the time of the termination trial in December, Mother testified that she was going to be going back into treatment, that she had set up so she could go back into treatment. But there had been a long period of time where Mom wasn't in treatment.
Well, Ms. McWilliams, I'm sorry to interrupt.
Sure.
Talk to me a little bit about the standard of review. Is AJL the right case?
Your
On
Honor,
the discretionary standard of review?
I do believe it is. Everything that counsel brought up in her opening brief is a factual determination that the court has to make.
When we're talking about reasonable efforts, 19-1-103-89 and 19-3208, those are legal statements, legal definitions.
But, I'm sorry.
No,
go ahead.
so clear error or deference to the juvenile court's findings on this, where do we draw the line?
Because, Your Honor, the reasonable effort standard takes into consideration the need for treatment for a family and the needs of the children in a case. That, in and of itself, is a factual determination about what happened in a case. So when counsel says Mom did not have enough time to do her treatment plan, this was an EPP case. Mom started working with the department on a voluntary basis in November of 2015, and then we filed the petition, let me get there, in April, I believe, of Yeah. We filed the petition in April of 2016. Mom then had from April of 2016 into December of 2017 in an EPP case.
So you gave an additional time.
We did. We gave her an
And
additional
your position
time.
was to give Mom some additional time.
Correct. And at the May hearing when Mom relapsed, we did not come in with a termination motion. We set it out for 30 days. We allowed Mom to get more time to get back into treatment. Ms. Zimmerman was still working with Mom at that time. And when Mom came back in June, she had either missed or tested hot for the month of May and the month of June. And it was only at that point that the department decided that the children's needs were that we go forward with filing the motion for termination. And that was filed at the end of June.
And you agree with Ms. Engelhardt that the judge found that the treatment plan was appropriate?
Yes, and that it was reasonably calculated to make her a fit and proper parent. Your Honor, the issues for Mom were both mental health and drug and alcohol. Mother had, one of the arguments in the brief is that we shouldn't have asked her to leave Dad. What happened was Mom was 7 months sober, and Dad was not. Mom allowed him to move back into her house even though she knew that he was using. And I think that the case that we cited in our brief, CTS, really covers this part of the argument in the brief. Mother's inability to separate, in that case, from a domestically violent father. She had done all of her treatment plans. She had actually been successful in CTS. But she still lived with her domestically violent partner. And the court stated that where a parent chooses to remain in a relationship with a person who poses a threat to the welfare of the child, the conduct of the parent may prevent him or her from providing protection adequate to meet the child's needs.
So did the treatment plan include the requirement that she protect from him or that he not be permitted to live in the house?
Your Honor, it did not have a provision that indicated he could not live in the house. When Mother was sober for a lengthy period of time, the question was brought up in court. He is not sober. He's not maintaining his sobriety. He either was testing for high levels of THC or methamphetamine during that period of time.
But there was not a domestic violence concern when he was around?
There was one domestic violence incident that happened. Ultimately, we decided that because it was only one, it did happen while they were living together, that we would allow her individual therapist to incorporate that into her individual therapy rather than requiring a full domestic violence component. But there was some domestic violence while they were living together, and he was still using his methamphetamine. So if you look at all of the requirements indicated as not reasonable efforts in the opening brief, the inpatient treatment, there were two separate times that Mom picked Salvation Army herself and brought it up to her treatment provider, Ms. Zimmerman, who indicated that it wasn't the right program. And then probation did offer her an inpatient program. She declined to take advantage of that as well. Your Honor, in this case is full of reasonable efforts. We went way beyond EPP guidelines to give Mom more time. We didn't move the kids into a more permanent home because we thought Mom was so close to reunifying with the kids. So we really juggled her ability to maintain her sobriety with the children's needs. When it became clear that Mother was not maintaining her sobriety and was not getting back into treatment in a way that would allow her to remain sober, then the children were moved into a permanent home.
And this was all brought out before the juvenile court at the termination?
It was, Your Honor. And it was throughout the history of this case. We discussed these issues at all of the hearings in front of the court because Mom did have two periods of sobriety, like I said. She had a period of sobriety while pregnant with ZS. She then relapsed while pregnant with ZS on meth in July, I think, and then got clean a second time and had 7 months of sobriety. And then in May of 2017 relapsed again, and then never, even though she had the therapist she wanted, from May until September, she never then was able to re-engage in her sobriety and be able to become sober.
But again, if we're giving deference to the juvenile judge's findings at termination, aren't we limited to the record introduced at that hearing and not looking back at prior review hearings or?
Your Honor, the record had all of that as part of it. The caseworker
Okay.
testified about the time of sobriety, that why we decided that termination was what permanency these kids needed. The other issue that counsel brought up was less drastic alternatives. In the closing statement, the trial counsel indicated that she was not actually arguing less drastic alternative, that she was saying that the children should be with grandma because even though grandma only wanted adoption, so grandma wanted termination and adoption, that the children being with grandma would give mom the ability to have some contact with the children. So it wasn't that grandma testified at the termination trial that she would do allocation of parental responsibility. It wasn't that grandma even told anyone that she would do APR. Grandma made it very clear she wanted adoption if she was to be considered as a placement, and she wasn't an appropriate placement. Your Honor, if I may give my time to Ms. Bettenberg.
You may. Thank you.
Thank you.
Good afternoon, may it please the court. My name is Allison Bettenberg, and I am the guardian ad litem on appeal. Gary Evans was the guardian ad litem at the trial court level. I think I want to focus, I think appellant's counsel spent a lot of time talking about the standard of review, but I think what's most important to look at is we have some very, very young children, 2 and 3 years old, the bulk of which they have essentially spent in the system. And I think from my perspective, the most pivotal piece or the biggest issue for me centers around the time in which a parent can become fit. And it's raised in the context of a reasonable efforts argument here, which I don't think is really what's contemplated in the statute. I think the court has to make separate factual findings that we've talked about today as far as what the court could find under 17-3604 as to whether or not the mother in this case could become fit in a reasonable period of time. When you look at HS, she's essentially involved with a court-involved non-voluntary case for 20 months. The EPP standards apply to her, and that was 12 months, and so that was really exceeded. Then you add an additional 5 months of a voluntary case. You may or may not be familiar with what those are. That occurred prior to the opening of her case. And then if you add in ZS, who's a later born child, once that other case is open, her case technically only is 13 months basically from the time she's born to when the termination hearing happens. But in the context of that, the court has to consider everything that happened in relation to these parents really over the course of HS's case. And that extends this time very great for the youngest child. And that's why, from my perspective, it's absolutely a factual determination.
So Ms. Bettenberg, I'm sorry to interrupt. So what's the standard of review?
I mean, I think that AJL is the appropriate case. I think there has to be deference about that. This court doesn't engage in fact-finding necessarily about what occurred at the termination hearing. You've got to review the record for what the trial court looked at, and if the factual findings are supported by the record, then you've got to affirm their finding. And here, that's related to fitness. So from my perspective, that's not really a reasonable efforts issue. It's whether you can become fit in a reasonable period of time would have required the trial court to find that additional months would have rendered a difference in what had happened. And I think Ms. McWilliams already touched on that in the latter course, there was and I think, Your Honor, you asked a question about the continuance that did happen as it relates to an expert witness that the mother wanted to present. That unfortunately had a big 2-month gap between hearing day one and the second day of the hearing. But in that time, all of that information would have been relevant had there been any sort of additional treatment or engagement. And it, for lack of a better word, simply just kind of stopped. And it stopped prior to the termination hearing starting in September.
Stopped, meaning her participation?
Her participation stopped, yes, that's correct. The referrals were never not in place. There was always referrals for treatment, and no one raised at the trial court that there weren't. There was never, in essence, it's a sad case. Mom did have a good relationship with the therapist that she had. That's absolutely true, but we can't change that somebody's job title changes and their agency changes. So we're left with that at the time of termination, there's just an enormous amount of extension of the EPP timeframes for these kids. And to go beyond that, the trial court would have really had to look at, well, there's been engagement since in the last couple of months. She really picked it up, even though this therapist left. Or that somebody had actually asked for a different result related to that therapist. That also wasn't asked for. She admitted that she tried to talk to her to see if she could do it, and she just didn't work at the same agency. And I don't know how it could be reasonable that the department, or really anybody, could somehow make this therapist be able to do something that really isn't able to happen. I think some of it related to Medicaid and those kinds of things, but again, it wasn't something that was requested. If that hopefully answers what your question was. I don't have anything further other than I would just ask the court to affirm the trial court's ruling. Thank you.
Thank you, Ms. Bentenberg. Thank you, counsel, today for your helpful arguments. People in the interest of HS will stand submitted. We will get you our opinion in due course. That concludes our docket for today, and the court will be in recess. Bailiff, you may so announce.